Hello, it is May 7, 2020, and we are doing our weekly webinar. This week's topic is how there are more appeal opportunities and also problems because of the pandemic. And this week I have two great appellate attorneys who are joining me. Many of you already know them. Scott Bassett is a family law appellate specialist who happens to have his home office in Bradenton, Florida. But he used to be in Oakland County for a very long time and was a trial and appellate attorney in Oakland County and still comes, well, I don't know about anymore because of the shutdown, but he used to be in Michigan at least, I swear, once a month I'd have something where I would have occasion to see him live in person. And then our other panelist today is Trish Haas. And Trish is in Wayne County, and she's been around for a while. She's worked on some pretty notable appeals as well. She also does trial work. And so we're going to just jump into this, talking about the timing of things and how maybe some clients may have some opportunities to appeal that they wouldn't normally have. Remember, there's a chat function. I will try to keep my eye on the chat function. If you have questions, I might even have an opportunity to call on somebody in the audience and ask you to unmute yourself. So we'll get started with our, appeal topics. So first of all, the big issue is the timing of appeals. As everybody knows, we have the Supreme Court suspended appellate deadlines. That did not happen for most deadlines in the trial court, but it did happen on appeal. And while a lot of us are still busy getting our deadlines done, we don't really have real deadlines anymore, which creates some benefits for our clients. So Scott and Trish, I'm going to open the floor to you if you want to share your thoughts about how our clients can take advantage of this unusual situation.
I guess I'll start, Trish, if you don't mind.
Absolutely.
We'll go with the much older person first. And because, you know, at my age, I'm always thinking about time and how little of it there is left. So what we're looking at here is March 24th as being the key date, because that was the date of the suspension of our filing deadlines for appeals. Now, what that doesn't mean is that when this starts up again, when the emergency orders are over, that you get your full appeal period that might have already partially run before March 24th. What that means is you'll get exactly the same amount of days you would have had otherwise, just with that big chunk of March 24th until whenever things open up again, not being counted. So anything that's as old as, say, March 3rd is still going to be able to be an appeal by right if you want to appeal a trial court order dated March 3rd. But the risk, of course, is that you know, nearly your entire 21-day appeal period will have run by the time this thing opens up. So you might have 1 day to file. And that's for appeals by right. The interesting thing about appeals by leave, until about 5-6 years ago, we used to have 12 months to do a delayed application. It was then reduced to 6 months. But if you take March 24th and you count back the 6 months, then we're going all the way back into September. So in theory, for applications for leave to appeal, you're looking at September 24th. So orders that old could still be subject to a delayed application for leave to appeal. So as you look at some of the orders that your clients may have wanted to appeal, it might be worth checking back in with all of them, advising them of this new opportunity. And, you know, if their reason was, I just can't decide that quickly, or I need time to raise money for an appeal retainer fee, that may no longer be a factor since we have that additional time.
And they still have time right now, because until the shelter in place or the stay home, stay safe order is lifted, there aren't any appellate deadlines. And obviously the big mystery that we're under right now is, when is that going to be lifted? We do not know the answer. We have some speculations, which we'll talk about a little bit. But I wanted to ask Trish a question about the orders that are entered March 24th or later. So we've had, you know, not as many, but some orders have been signed and got out the door since March 24th. What happens to those clients who normally would be past the time to appeal right now because it's been well over 21 days?
Well, because of the order that was issued by the Supreme Court, and it's specifically Administrative Order 2020-4. And I would like to note, it specifically told all filing deadlines so long as the stay home, stay safe order remained in place by the governor. So essentially what that means is that all filing deadlines were frozen as of March 24th. So for example, if you had an appeal deadline of March 25th, right now you would actually have 2 days after the stay-at-home order is lifted to file the appeal of right or the application, as Scott had mentioned. I think it's very difficult to keep up with the orders. I've tried to keep up with them, and it is interesting because some of the orders are tied to the stay home, stay safe order, and then some are actually tied to the emergency order. But in the case of appellate deadlines, it's actually tied to the stay home, stay safe deadline. So it's as if time was frozen so long as that order remains in place.
And if an order was entered after March 24th, the deadline hasn't started yet. So what we believe, our educated guess, is that once we're told that we no longer have to shelter in place, let's just say hypothetically, May 15th is our last day to shelter in place. We don't know that that is the case. Then that's a Friday, so that the following business day is Monday the 18th. Then the clock would start ticking. Day one of your time to file an appeal by right would be May 18th, and you'd still have 21 full days to get in your timely application, your timely appeal by right, or obviously 6 months to file a delayed application. So these deadlines are going to be different for probably the rest of the year because of the 6-month period for delayed applications. Trish, you made a really good point about how confusing it is to keep up with these orders. And I know you and Scott both identified this morning another Supreme Court order and more Supreme Court guidelines. What I've done is I created a resource page on our website for family law and appeals, and it's mostly relevant to family law, but some of it is appeal specific, where we've put all the orders or guidelines or memos on our website just to make it easier to find, because it is super hard to keep track of. So I'm just going to put that in the chat button if anyone wants to look at it. I've just used it for myself every time I have a question, rather than trying to try to remember who issued it. Was it the governor? Was it the state Supreme Court? Was it SCAO? And trying to remember who might have issued it and where I might be able to find it. I just have them all in one place. So I wanted to share that.
Lisa, another complicating factor here is that yesterday's Supreme Court administrative order focuses very much on the local surroundings of the court, what's going on in the community for the trial courts. And I'm wondering if we're going to be faced with a situation, and we don't know if this will happen yet, where your appeal deadlines might actually change depending upon which county or which circuit your order is from, because some circuits will clearly be opening up earlier than others. So, are we going to have orders that are coming out at different times? What's that going to mean for the appellate process? All that's unanswered right now. The, I don't know how many page, 27 page or something like that, guidelines that the State Court Administrative Office issued yesterday to go along with the Supreme Court's administrative order goes through all of the standards and phases. There's 4 phases for reopening. So this is going to be complicated. It's going to require a lot of diligence on the part of trial and appellate lawyers to monitor these orders as they come out.
Absolutely. And I did post, and I haven't had a chance, I'll be honest, I haven't had a chance to read those guidelines, but they are posted on the COVID resource page on my website so that I can find them later. One good question that Evelyn asked had to do with transcripts, and that actually leads us to our next point that we wanted to make, was that the suspension of appellate deadlines is not just for case initiation, it's for everything. Every brief, every docketing statement, and yes, to Evelyn's question, to court reporters and their transcript deadlines. Now, I would like to spend a couple minutes talking about the transcript deadlines, because some people may be using it as an excuse not to prepare transcripts, but I think there's a bigger implications than that, because there are counties, and from what I've learned, and maybe Trish and Scott can weigh in, where the court reporters just cannot get the recordings in order to do a transcript. So they don't have a deadline, thank goodness, because they physically are not able to get what they need so they could do it from home. So Scott or Tricia, do you have any anecdotes that you can share with us about that?
Well, maybe Trish can start with this because, you know, she practices, her office is in Wayne County, and Wayne County is responsible for a huge proportion of the appeals in this state, but also has special transcript issues. And that's something that we've had issues with even before the pandemic, but during the pandemic, it's a bigger problem.
Yes, I think because Wayne County Circuit Court is in fact closed, there's no access to it for the most part right now. That means that it's like Lisa said, that court reporters are unable to actually access the transcript, to access the recording so that they can prepare a transcript. I am hoping that commencing next week on or about May 11th, that this will change. But for now, I know that I'm finding it seemingly impossible to obtain transcripts from Wayne County at this moment in time, and really for the last essentially 7 weeks. I'm not sure how the other counties are. I will give a shout out to Oakland County reporters because I have received some transcripts in during the pendency of this, but I think that's the exception rather than the rule.
To add into Wayne County, Trish, is Washtenaw County, which has been impossible to get. It's been impossible for a court reporter even to get in touch with somebody in order to get an audio recording that they, I think, could circulate by email. Scott?
Yeah, this is one of those areas where technology makes a huge difference. Oakland was one of the first counties to go with digital case records. Unlike many other counties, when they transmit a file to the Court of Appeals, once the briefs are in, it goes electronically. And other counties are starting to do that too, but for a long time, Oakland was the only one doing it. I'm wondering if Oakland's ability to be able to access digital recordings and get them out to the contract court reporters who prepare the transcripts makes a difference for Oakland. And it's why Oakland is a step ahead. In Wayne, I don't think there's any mechanism to do that. The recordings are physical entities. They're not stored on a server somewhere or they can be accessed remotely. My hunch is in Oakland, I think they're stored on a server.
So also in Wayne County, there's an added layer of difficulty, which is the court reporting services. If you make a transcript request, it has to go through court reporting services. In good times, it would take a couple of weeks for CRS to get the transcript request to the court reporter, at least in my experience. And so, for example, we ordered an expedited transcript at the beginning of March before the shutdown. But by the time the court reporter received it from CRS, it was right when the shutdown was happening. And of course, we have no sign of any kind of expedited transcript whatsoever.
Right, and if it's a custody case, we only have 42 days to get that transcript done. And then we start getting involuntary dismissal notices from the Court of Appeals, which then puts the burden on appellant's counsel to take action to either file a motion to extend the time or potentially show cause the court reporter, which is something none of us ever want to do.
Well, the good news is that those deadlines aren't applying to us right now, but we should know that we're getting defect letters. Like they're being automatically generated by the Court of Appeals when they see we haven't filed a steno cert within 7 days. It's just their system is automatically blasting it out, and that, you know, it says you have to do this within 21 days or else. But we've called the court like, wait, why did we get this? Everything's been suspended and we can't get a hold of the court reporter. So they said it's just, don't worry about it. It's just something that's automatically generated.
What's going to happen in a lot of these counties is that once the orders are lifted and we're starting to count time again, there's going to be a big backlog of unprocessed, untranscribed hearings. And I would imagine we're going to see more defect letters, more involuntary dismissal notices than we have ever seen before, you know, starting sometime late summer or early fall.
I was going to comment that, interestingly, I did call Grand Rapids about a defect letter that was sent to me. And when I received a call back from the court, they indicated to me that I was the only one who had complained about the fact that they were still generating dismissal letters, despite the fact that the Supreme Court order indicated that all filing deadlines were told. So I found that surprising because
It is actually very surprising, Trish, because I know my office has called. John Cece is reporting to me that he has called. I mean, I think a lot of us have called because we're like paranoid, you know, attorneys, we're like deadlines. We have deadlines. But yeah, that's, maybe that just happened to be that one clerk at that one office that hadn't had that call before.
Just to clarify, when Trish says she called Grand Rapids, the Court of Appeals has 4 district offices: Detroit, Troy, Lansing, and Grand Rapids. So when we refer to calling Lansing or calling Grand Rapids, we're referring to calling the district office at the Court of Appeals.
Indeed.
So Scott mentioned a few strategy, things for your client who might be considering who might want to consider appealing an order that would otherwise be too late to appeal, but now they have this opportunity that they did not have before. I think Scott, you mentioned the fact that some clients just couldn't make a decision in a rush, especially facing a pandemic. I mean, there's a lot of extra stress that was going on in people's lives. So they do have more time to decide. And, if they're going to do it, it's better to decide earlier than later, but there is still time to make that decision. Scott, you also mentioned that it gives them more time to raise funds. Obviously, a lot of clients most people are under a pinch, but, it gives them more time to figure out what they're going to do if they can appeal. I was thinking, and Trish, feel free to add, I mean, if there's any way to negotiate something, probably not by the time it's going to appeal on a family law case, but if there's any opportunity to negotiate something, you can do that now before an appeal's filed. So before the $375 is spent, before you have to do the work of getting whatever filed, whether it's an appeal by right or an application, there is this window of opportunity to negotiate something. Because let's talk about the effectiveness of the orders. Do you want, either one of you want to comment about that? Of the timing of the effectiveness of the trial court orders?
Well, we can talk about that. We can also talk about the effectiveness of Court of Appeals opinions too. I just want to start off with that because it's something that I faced. I was able to get a reversal in a Wayne County child custody case, but because the reversal order opinion was issued April 2nd, none of the periods for enforcing were starting to run. And depending on how long the shutdown was, and we were counting on, this is a case where the kids will now need to go from Michigan to California. We were counting on doing that when school was out. Well, unfortunately, there's no way, we don't think, that if the shutdown lasts much longer, that we would even have an enforceable Court of Appeals decision. For those of you who don't do much appellate work, a Court of Appeals decision is not enforceable potentially for longer than 42 days. There's a 42-day period to go to the Supreme Court with an application for leave. If it's filed timely, and there's no such thing as an untimely application in the Supreme Court, that's jurisdictional, then once that application is pending, you still cannot enforce until the Supreme Court decides. And you can stretch that out even more by asking for a reconsideration of the Court of Appeals decision. You have 21 days to do that. The court will usually resolve that within another 2 weeks or so. But you could be looking at, potentially 80 some days before you have an enforceable Court of Appeals decision. So one of the techniques that I tried in this particular case was to file a motion for what they call exceptional issuance. Wait,
can I pause you for a second, Scott? Sure. When you said 80 some days, you mean if they don't go to the Supreme Court?
Correct. If they don't go to the Supreme Court, right. If they do
a motion for reconsideration to be decided, and then another 42 days after that, that's about 80 days. But if they went to the Supreme Court, it could be another 6 to 10 months. Okay, go ahead.
It could be. Exactly. That's if they don't go. Exactly. That's just, if somebody is determined to, if they lost in the Court of Appeals and they want to stretch it out and frustrate enforcement efforts, they could stretch it out that long. But the appellate court rules have this thing called exceptional issuance, which really means immediate effect. And you can ask the Court of Appeals for immediate effect of one of their decisions. It's rare. Occasionally they will issue a decision that has immediate effect built into it. Some of you may be familiar with the Jacob versus Jacob decision. It's an unpublished case, but it was released in the last 6 weeks or so. And that was actually had an immediate effect provision written into the opinion, but that's very rare. It's one of the few I've ever seen, but you can ask for it on motion. So if you're stuck in one of those positions where you have a client who has prevailed in the Court of Appeals, gotten the trial court reversed, one of their best options may be to ask for immediate effect. And in my case, I was fortunate they granted immediate effect. So we are now able to enforce that reversed child custody decision.
And that other party could still go to the Supreme Court, but the bottom line is your client can move forward with what the Court of Appeals said should happen, even if they decide to go to the Supreme Court, which it sounds like your client's children will be moving to California.
That's what it looks like, unless something happens.
And I just filed one of those motions this week or last week as well, Scott. So I'm keeping my fingers crossed that we don't have a very long delay in that case. which could be a long time if they go to the Supreme Court.
Yeah, the other thing we're dealing with now is basically a tolling of enforcement under MCR 2.614, the trial court orders. I think we all know that there's a 21-day automatic stay of most what we would call final orders, which in domestic relations cases would be the judgment of divorce or post-judgment orders that would be appealable by right, like a child custody order, for example. It is possible to make a custody order immediately effective and enforceable, but only if the court orders that for good cause. So we've got that issue that's being extended out under these rules, and it doesn't appear that the 21 days under 2.614 even starts to run until after these emergency orders are lifted.
Trish, was there anything you wanted to add?
Well, I would agree with that, but I think the one thing that perhaps people should remember is that MCR 2.614 does permit filing of a motion. Perhaps it is an emergency that the order be enforced immediately, notwithstanding Administrative Order 2020-9, which suspends, essentially suspends MCR 2.614. Perhaps there is a go-around if the court would then consider that an emergency. But it is interesting to think that any orders essentially entered after March 24th or March 24th or thereafter are not enforceable right now because of the suspension of the automatic stay. It's an interesting concept to think about, but I think that perhaps maybe there's an opportunity to file an emergency motion if the circumstances exist.
Mm-hmm. Or anticipate the issue, because now that we know that 2.614 is being told, as you ask for relief in the trial court, as trial court counsel, you may want to build into your motions or to your argument, if you're actually doing a Zoom hearing, an evidentiary hearing, add in a request for immediate effect and ask the court to make a good cause finding, so that you don't have to come back in after the fact and then file a motion for immediate effect. If you can head that off by asking for it in your initial request for relief, your client will be better off for that.
So I didn't do a poll, and I'm afraid of trying to do it while we're on the Zoom because I don't want to get us logged off. But does everybody know where the raise hand function is? If you hit the manage participant button, there should be a button that says raise your hand. And I'm going to ask a question because I'm really curious, and I can't raise my hand, but if you've received, Bill doesn't even know the question, he's already raising his hand. I love the enthusiasm. If you've received an order that was entered have there been orders in your county entered after March 24th? Raise your hand.
A few.
It's not many. So we have a couple of Kent County. Melissa, was it Oakland County or Livingston County?
It was in Oakland County.
Okay, and then Bill? William, what county was yours in? Oh, wait, hold on. I'm mute.
He's still muted.
I'm sorry, I did not get any.
Oh, you did not get any? Okay, sorry. Shalini?
Washtenaw County.
You got an order out of Washtenaw County? Was it on an emergency motion?
Yes.
Okay, that would explain it. Because Washtenaw and Wayne have only been doing emergency motions, and there's, obviously a totally different topic about what is an emergency and what happens if they don't think it's an emergency and they don't. But look, all these people that are attending, we only have a handful of people who have seen orders issued, and I'm trying to think if I received any. I think, I've seen one. I've seen one order in a case out of Southwest Michigan.
I will say that the Court of Appeals is still responding very effectively and quickly to emergency appeals. I had an emergency order that came out of Washtenaw County that I did an emergency application for leave to appeal, and we had a decision from the Court of Appeals in less than a week.
Yeah, I wanted to talk next about the changes actually in the appellate courts, putting aside the change to the deadlines. What changes have we seen? And one point that Scott makes is that the Court of Appeals and the Supreme Court are still working. They're full steam ahead. Everybody's remote, I think, but they're still deciding. They're issuing opinions. There's been a couple of published opinions pertaining to family law cases, in fact, that have come out since March 24th. They're issuing lots of unpublished decisions. The Supreme Court's issuing orders, and they've issued other opinions in the Supreme Court cases. So also arguments. Let's talk about oral argument. Trish and Scott?
Well, I was, my cases that have fallen within this period I've been denied oral argument. The case was submitted without oral argument, which was something the Court of Appeals could always do at any time. But traditionally, when you requested oral argument, everybody was granted oral argument. And since these emergency orders were put in place, that is no longer the standard. I do believe that Lisa had the opportunity to participate via Zoom for one of her oral arguments. But I think for the most part, most cases are being submitted without the opportunity for oral argument.
Yeah, as the old guy here, I've been doing appeals for 39 years. In those 39 years, before this pandemic, I had only one case where the panel decided to decide it without oral argument. Out of hundreds of cases, I thought that was pretty extraordinary because it's always optional. The panel could always dispense with oral argument. The rules provided for it, but they just never did until recently. And my last oral argument in the Court of Appeals, live in-person one, was mid-March. And I don't expect to see another live in-person one until August at the earliest. So, I think what we're seeing is wholesale cancellations of oral argument. Only a handful of oral arguments went forward in April. I think one was one of yours, Lisa.
There was only one in April.
Only one in April?
I haven't found out if there are any in May. There may be, but I don't know. I haven't figured out if there are any in May.
I haven't heard anything either. One of the disadvantages is that as I understand it, and I think, Lisa, you're the one that was the source of this information, the panels were given until only 8 days, I think, before oral arguments started to decide whether or not they were going to hear argument in a given case or decide it on briefs. That, of course, puts appellate counsel in a difficult position. Puts me in a difficult position because I have to book flights and fly up from Florida, and others. If you're a Detroit practitioner and you've got an oral argument in Grand Rapids, you have to plan to get up to Grand Rapids, typically driving up the day before. So there are some logistics that need to be dealt with. But I'm expecting we have the June case call has already been posted, and we have been told that we may not have any word for a couple of weeks on whether or not any of those will be done with oral argument by Zoom or otherwise.
And at the rate, based on history, it's going to be several weeks before we know that answer, right? Right. So and last month when we found out, we had arguments in front of multiple panels in May, and some of the panels were really fast. So, within a week or so of getting the schedule, we found out it was canceled. But there was like one or two panels that was where I think the court ended up, I think that's what happened. The court had to say, hey, you guys, we have a deadline. We've got to let these people know whether they're going to have to argue it. And then we have to figure out, we as the court have to figure out the logistics of doing another Zoom argument. And so they put the panel on a deadline, and that's, how we found out. But every single one of ours has been canceled except one case that we did in April.
Am I correct that the only oral arguments that have taken place by Zoom have been assigned to panels in Lansing?
Well, there was only the one in April, and it should have been, that case came out of Jackson County. That would normally be Grand Rapids.
Right.
But it was, the panel comes from all over the state. So it was because the panel had questions for us. That was all that it was about. I mean, we got in there, no factual recitation. Let's just get in there and start answering the judge's questions. And that's what we were there for. And it took about 30 minutes to do that, for the two parties to answer all the judge's questions. And they were like really down to business. We have questions, we want answers. So it wasn't like, when you normally go to court, you have to sit through people rambling on and on and on. And there's complete radio silence from the panel and somebody's still talking. That wasn't like it at all, because they truly did have questions, which is why they invited argument.
Yeah. How many, maybe we can do another show of hands, if you don't mind, Lisa.
Yeah.
How many of you have actually been present during a Court of Appeals oral argument to see what they really look
You
like.
look, do the raise your hand button. I think
Yeah.
most of these people have.
Okay. My experience has been that the vast majority of oral arguments are bordering on useless. And I predict that now that the court has an incentive to say no to oral argument and decide cases on briefs only, I think it was basically inertia that caused them to grant oral argument in nearly every case. And that inertia is now gone. And I think we're going to see far fewer cases selected for oral argument, only those cases where the panel decides that they really need it. Now, I don't know how that's going to affect how much notice we get of oral argument. Traditionally, usually on a Saturday at the beginning of a month, the Court of Appeals will post the case call for the following month. And I don't know if that will have to be delayed or not to give whether or not they're going to even have argument in those cases.
So Matt Kachik asked a question, and maybe I'll lob this one at Trish, about how important is oral argument in our appellate cases, and what are we really losing out on by not having it as much as we did before? I'm sorry, I paraphrased me.
Okay, well, it's interesting because I know that there was discussion amongst the three of us and some others that perhaps oral argument shouldn't be automatic in every case. But my point in that regard is that from the perspective of the client, I think for our clients, it's important to know that they are getting their day in court. And I've sensed that there's been a lot of clients of mine that have been unhappy with the fact that while they were waiting for their court date in the Court of Appeals, they're now being told that, I'm sorry, you're not going to have your day in court. So from the perspective of the client, I think it is unfortunate at a minimum. From an appellate attorney standpoint, though, I would have a tendency to agree that oral argument very rarely changes the outcome of the case, unfortunately.
Well, and in large part because the court's making a decision on, 95% of the decisions made on what's been filed, the briefs and the trial court record. And really, what's the point of argument? It's to answer the court's questions. And so when we sit through these arguments where there's no questions, it's kind of boring because the court doesn't have questions. And even, I don't know, tell me if you guys agree with this, but even when they do have questions, it's often not because they're trying to decide what to do. It's more like, how are they writing a specific sentence in the brief? In the opinion, and it might like frame a little bit about how the opinion's written, whether we win or lose that case. But it doesn't actually change the outcome of the case, except maybe, Scott, tell me how many times in your career you think it made a difference.
I can only think of 2 cases in all the years I've been doing this where I think the oral argument changed the outcome. One was a step-parent adoption case. The other was a change of domicile case within the state of Michigan that Trish and I had. Sorry, didn't mean to mention that, Trish. But Trish, Lisa, and I are members of an organization that doesn't formally exist. It's called MICFLA, the Michigan Coalition of Family Law Appellate Attorneys. The other members are Judith Curtis, Ann Argeroff, and Kevin Gentry. And we're often opposing counsel with one another. And we actually met with the Court of Appeals about the whole oral argument issue and whether it was really all that necessary, and almost hoping to trade off oral arguments for a more liberal final order rule, which we thought we were getting, but of course the sad story is that it was pulled away from us at the last minute. Well, it's a year and a half. School change and other types of orders that we thought should be appealable by right no longer are, and are simply appealable by leave. But that's, we've been working, I think, toward the oral argument in many of these cases isn't even all that important.
Now, we've been talking about the Court of Appeals. Same question for the Supreme Court. I think the answer might be different. Trish, Scott, we've all had Supreme Court cases on leave grant.
Different in the Supreme Court. The Supreme Court's a different animal than the Court of Appeals. Much, much lower volume. I mean, you have to, in some ways, sympathize with the Court of Appeals judge. These cases the same time we get our case call notices. So they don't have much time with these cases either. And they've got dozens of cases to deal with every month. And the Supreme Court, when a case is decided after full oral argument, I think we're down to maybe 50 a year. Does that sound about right, Lisa? Part of that's been affected by the rise
again?
of the number of actual leave grants with full.
Oh, yeah, like 50.
Or maybe only 50 a year, roughly. We do get some MOAs, mini oral arguments on application. To my mind, a horrific process that has given the Supreme Court to grant leave in any family law case ever again, although I imagine it happens once or twice. But and there's been some grumbling even among justices of the Supreme Court as to whether that process has been misused and whether, but a much smaller volume.
Wasn't Allard a leave grant case?
I'm not sure if that was a leave grant or a
But they
MOA.
only decided with an order. So even if it was a leave grant case, they decided it was an order. So.
To have a decision on a complex issue in a half-page or one-page order, that's a problem because you don't have room for analysis. It doesn't provide any guidance to us as appellate practitioners, to all of you as to referees or to trial court judges. So that's a real problem. But it's completely different. I think that oral argument in the Supreme Court is very useful. The kinds of questions you get, I think, are much more what you see in the Court of Appeals. I mean, there are exceptions, of course. Last time I was in the Supreme Court, actually, Trish was my opposing counsel, and she won 7-0. So I think.
Was that AJR?
Yeah, that was AJR, the step-parent adoption case. But I guess I'll claim ultimate victory since the legislature's changed the statute to align to where I wanted it to
And
be.
in my humble opinion, the Court of Appeals screwed it up again when they were analyzing the revised statute. So.
Every time I have a case win with you, I win, I always lose the battle ultimately. Well, you know what I mean.
So, and Evelyn concurred, she had clerked at the Michigan Supreme Court, and she said the oral argument did change her justice's mind on multiple occasions. So a couple other things happening at the Court of Appeals that are being handled differently now that we're in the shutdown, stay home, stay safe order. We didn't end up filing, but we were going to do an emergency appeal on a summer parenting time issue. And because the order was going to go into effect like in a week, I mean, technically it wasn't going to go into effect at all, but according to what the order said, it was going to affect in 7 days, and the kids were going to be moving to a different part of the state for the summer parenting time. We were about to do an emergency appeal. We couldn't get the transcript. And what we ended up doing is calling the Court of Appeals, and they said they would accept the Zoom recording in lieu of a transcript for purposes of this emergency appeal. So I don't think it's a replacement for all of our cases, but at least in an emergency case, we do have counties around the state that are holding hearings, including evidentiary hearings already. It may not be Wayne or Washtenaw, but there's other counties in the state, even northern Michigan counties, Oakland County, they're holding, Ottawa County for sure, they're holding hearings by Zoom. And if you need to do an emergency appeal, but you can't get your hands on a transcript that quickly, you can at least give the Court of Appeals the Zoom recording so they can, so they know that what you're saying in your application or whatever it is true. So is somebody sharing a screen? Hold on a second.
It looks like there's a meeting registration popped up.
Okay, hold on.
This works, so.
My screen keeps on changing and I'm not doing anything, so. Okay, well.
There we go.
Okay, I think there's a way to, let's see, lock the screen.
Lisa, if I can add something to the
absolutely.
To the Zoom if that's
Go
so
ahead.
possible, because I've had to do this on emergency appeals even before the Zoom era that we're now in, where if you needed a transcript right away, you can hire your own court reporter to review the audio or video, an informal transcript to submit. But I also wonder if we're nearing the end. It probably won't happen while I'm still practicing law, but there is one state, I think it's Kentucky, that no longer requires written transcript. And I think we may be heading in that direction now that we're all becoming more comfortable with this technology, where the video or audio recordings will be submitted in place of a transcript. It'll happen, but I think it will happen.
Another topic I wanted to talk about is how is the Court of Appeals viewing these, what we would normally deem an emergency in family law when something's going to happen, like parenting time's been suspended or a new parenting time schedule is going to go into effect immediately that has kids moving around the state or whatever. We might normally pursue those on an emergency basis. I wanted to ask our panel if they have a sense, a feeling about how the Court of Appeals is looking at those quote unquote emergencies now that the whole country's in an emergency situation. Are they being more critical of those situations and maybe not as willing to give relief because everybody's in an emergency situation?
Well, I haven't personally filed any emergency appeals during this period. I have filed emergencies in the trial court, and unfortunately, things that I've deemed an emergency are not being deemed an emergency by the court. But again, I don't know how the Court of Appeals is treating such issues right now. And but Scott has experience with this right now, so I will defer to Scott.
Yes, I have done an appeal on a parenting time issue, and it was COVID-19 related because in the custodial home, there were two children, a high school senior with severe autoimmune, and then a 1-year-old. The father, who had supervised parenting time only with the 1-year-old, was to take place in the custodial home. And the issue was whether him coming into the home would undue risk to the high school senior in the home. And it was decided on an emergency basis by the trial court judge. We took an emergency application for leave to appeal. But my sense is that the looking disfavorably toward anything that modifies existing parenting time orders because of the pandemic. Even though a public health official, hey, this is a serious problem, I'm not sure that the courts are necessarily buying into that. I think what we can expect to see is a trend toward as they existed before. And I think, as we've seen in the FAQs that have been issued by the State Court Administrative Office, where orders may be tied to when spring break is or when school is out for everybody right now, except for distance learning, online learning. They're expecting people to abide by those schedules as if school were still in session, as if life was still going. But I think that's kind of a legal fiction that we're creating here.
So, Scott, in the example you just gave, the trial court declined to modify the parenting time schedule.
Correct.
What about the opposite, when the parenting time schedule is being modified by one parent without a court, whatever, and the trial court's modifying it or allowing it to be modified? Do you think the Court of Appeals will be a little bit more gracious with the appeals that they get on those issues?
Thinking more willing to reverse, maybe. It's hard to know, because I think all of us who do appellate work know that there's a strong tendency on the part of the appellate courts to affirm wants to do, as long as there's any rational basis to support it. It may not be what they would have decided, if they were sitting as a trial judge. But I think most appellate judges have a very clear sense of their role and the appellate standard of review that they have. You can almost see sometimes at oral argument and sometimes reading between the lines of a decision from the Court of Appeals, you can tell that they didn't necessarily agree with what the trial court did, but they also recognize court judge and should not substitute their judgment for the trial court. So I would expect that, you know, I don't know if a trial court changes it based upon a COVID-19 concern. I don't know, I've seen any of those yet.
So Trish, I have a question for you because we were talking the other day about, you know, when a trial court makes an error earlier in the case and you could appeal, but you don't, and that might lay the groundwork for the next 15 to 24 months. And I think, you know, I'm happy to hear your opinion, but kind of the gist of it was you think at this point you would appeal anytime there was a legal error early in the case to avoid that from happening. So my twist to that question is do you have the same thought when we're in the pandemic? Does that change your analysis at all of how you're looking at this order that is entered without following the law?
No, I can't say that the pandemic would influence my opinion in that regard. I think anytime a trial counsel receives an order wherein there's a change in custody without an evidentiary hearing, I don't think it matters whether there's a pandemic or not. I think it's important to take action at that point in time, because unfortunately the appeal period can run for such a lengthy time that effectively the established custodial environment is changing during the pendency of the appeal. And this is particularly important right now when there's no question that the Court of Appeals is going to be behind in issuing its rulings, because essentially there's been just a vacuum wherein a lot of people aren't filing their briefs. So you're potentially looking at even a longer period in time in which you're allowing a new established custodial environment to form. So I think it's important that anytime you're a trial counsel and you get an order that you know was entered without an evidentiary hearing that changes custody, or perhaps it's a suspension of parenting time, you should be expecting that the court may very likely continue that order, and that it may have long-lasting impacts that you are essentially unable to reverse on appeal. And that's consistent with the Supreme Court's order in Daly, indicating that, you know, it's impossible sometimes to change the status quo ante when there is a change in the established custodial environment. So I think that's something very important for any trial counsel to continue to consider. And even if there's a pandemic, an appeal should be filed, perhaps an emergency appeal.
Just to clarify, you're referring to Daly versus Ward, correct?
Yes,
Okay.
yes.
Different spelling than the other one.
Yes.
So I just put it in the chat in case
Yes,
anyone
thank you very much. I don't
So
know.
we have a few minutes left, and I think, of course, we're open to questions if anybody here has appellate questions, but we're going to chat a little bit while we have a few minutes left about appeal issues that we see coming out of, you know, having these evidentiary hearings versus Zoom and the things that we're doing now. Do those create any special appeal issues? Scott, did you have any comments?
Well, I mean, obviously you've got the issue of, and we talked about this the other day, the question of credibility. What this reminds me of is the People versus Kavanaugh. It was a criminal case, came out of a drug bust near Grand Rapids. And that was a case where the Court of Appeals said it owed no special deference to the trial court's review of the dash cam video of the arresting state trooper, because the appellate court could review that the same way that the trial court could. The Supreme Court, I don't know if they granted leave, I think it was a MOA on that, and they kind of left the Court of Appeals decision intact. But I think we may be facing the same thing with Zoom hearings. It is much harder to judge credibility when you're not sitting 2 feet away from somebody, a witness, for example, or a party, you know, watching them sweat in the courtroom. And if it's just video, does that change the whole concept of special deference to the trial court in assessing credibility? So many of our family law decisions are based upon, you read the trial court decisions, you know, a lot of them have credibility issues as the deciding factor. And, you know, the Court of Appeals has been reluctant to interfere with the trial court's view of credibility, but will that change with Zoom hearings, where we're all basically reviewing and have access to exactly the same record, and there is no advantage the trial court has under those circumstances?
Trish, do you have anything to add to that?
Well, I think that's a great point, Scott. And I'd also like to add that I think it's unfortunate that so many of our family law opinions turn on the trial court's determination of credibility. And up until now, there has been no effective way to remedy that, to get such a decision overturned on appeal, because the Court of Appeals always defers to the trial court's credibility determinations. So as much as I am not a fan of a proponent of evidentiary hearings via Zoom, because I do think that credibility determinations will be difficult to make for a trial court judge over Zoom, I would like to think that the upside of that is that perhaps the deference provided to trial court judges in regards to credibility will not be as important as it has been in the past.
If the Court of Appeals is willing to watch a video, and then there's the added question of what's the best way to get that video to the court? We're not allowed to, I don't think, give them a link, well, to a big document, but maybe there's like a Dropbox that we could link to or something. I don't know if you have any thoughts about how we would logistically.
There isn't currently. Yeah, there isn't currently. I mean, these days, and I have submitted videos when I thought it was appropriate, when I thought it added something that the just cold written transcript didn't add. But that's even in this era of e-filing of everything, that's typically involved, taking a DVD, putting it in an envelope, and mailing it to the clerk's office.
Oh no, 5 copies of the DVD.
Right.
5 copies.
Right. Exactly. 5 copies of the DVD.
You have to do 5 copies.
Right. That's one of the great advantages of electronic filing, is reducing the amount of paper that we used to have to file. I've been down here in Florida since 2002, and that was well before we were doing e-filing in the Court of Appeals, and way before the Supreme Court didn't start doing e-filing until January of 2015. So that's very recent. And especially in Supreme Court filings, especially in a leave grant case where I had to send up close to 30 copies, I'd have to set aside a week before my deadline just to have the copies run and shipped to the court, and ran copy bills of $500 to $1,000 and shipping bills of $300 just to file the paperwork. So thank goodness that we have electronic filing. It's a lot easier to copy a DVD, of course, so that's not quite as big an issue anymore. But there should be a better way. Maybe that's something we need to talk to the court about. But I want to get back to what Trish said about the whole issue of credibility determinations. At the last appellate bench bar conference, I think I mentioned that I think it's simply fantasy to think that trial judges, no matter how experienced they are, develop this sixth sense to be able to tell if somebody is lying. I don't believe that's true. Judge Redford, a Court of Appeals judge, used to be a Kent County Circuit judge, came up to me afterward and said he thought he had that skill. And maybe he does, maybe he doesn't. But I just don't think there's any scientific basis to say that a trial court judge or referee, sorry, referee's on the line here, who can say if somebody is lying or not. Everybody has their own different psychological makeup. They get nervous when they're testifying. Some people are good test takers, for example, some aren't. Well, appearing in court is kind of like taking a standardized test in a lot of ways. Some of us are good at it and some of us aren't. Some people are good witnesses, some aren't. So I think you need to listen to the substance of what they say and not be so focused on demeanor. But that's just my perspective as an appellate lawyer. And I did trial court work for 22 years, so I still think that's true.
And then one last question I had was about how these proceedings are being recorded when we're doing the Zoom evidentiary hearings. Obviously, there's a button to record on Zoom, but are the judges or the referees, and if you are one of those, please feel free to put something in the chat. Are they still doing the recording the way that they normally would, whether that's hitting a button and writing down the time you started, or having, in some courts it's a stenographer, and so of course the stenographer probably is not in the courtroom with the judge at this point, but they may be in a few weeks. Or is it a CER where they can make a recording and then have it sent out to be transcribed at some point down the road? Do we know anything about how those recordings are actually being made right now to make sure we have a good record for appeal, regardless of what happens in the case?
Well, I see referee Letourneau McAvoy indicated that all recordings will be through Zoom in Wayne County, and that was my understanding as well. So, and then I see referee Housey's weighing in, saying
Oh,
that they're
good.
going to be recorded on the cloud or on hard drives.
And referee Howler says hearings have been recorded the exact same way. Okay. So there's going to be basically there could be two recordings, and the Zoom recording and then the normal way, right? Which is good, because one of the things I think, Scott, when we were talking the other day, you were concerned about how Zoom is not hooked up to the court system for recording. It may not be as good of a quality, hypothetically. I mean, can you imagine the court reporter who's not in the courtroom having to, it's already hard enough to transcribe something when you weren't the one in the courtroom with the parties and the judge, but now you have another layer of distance because now it's a Zoom recording where the mics are not like hooked into the system or whatever, and maybe not as good of a recording.
Right, and people using, smartphones without mics, or using laptops, with mics that may be substandard. So, the audio quality on Zoom is not likely to be as good as it is in the courtroom.
And I'm new to Zoom, quite frankly, but it appears that with Zoom, people can't talk over each other. Is that correct? That's one good thing, I guess.
Wait, they can't talk over each other?
Yeah, I mean, I don't see that there's the ability to really talk over each other via Zoom, or maybe I'm just,
look, I'm talking over you right now.
Oh, okay. Well, thanks, Lisa.
We've just been a super polite bunch, which is why we were not talking over each other, but I had to pay really close attention. That was actually one of the things I learned when I did my Zoom oral argument. Like I had to watch the cues of the judges. At least I could look them, watch them to see if they look like they're about to start talking. Because then if you get multiple people talking, it's going to be really hard to control. And then of course everybody else is muted. It'd be really loud if we had a bunch of people off mute. Do we have any closing thoughts from Trish and Scott?
Well, I just wanted to say something that I just happened to notice. Again, reading all these orders at times can be confusing. And interestingly enough, the order that suspends the stay of proceedings, MCR 2.614, on April 27th, the Supreme Court issued an order 2020-12, which indicates that that particular order extending or essentially suspending a stay of proceedings or suspending enforcement is actually extended until further order of the court. So at this point in time, there's no deadline when this ends. So I think all of us need to be wary of that when we're in the future. I mean, I haven't had a lot of hearings, but hopefully that will change.
You're talking about 2614, right?
Correct.
Yeah, okay.
By Administrative Order 2020-12, which was issued on April 27th, that administrative order was extended until further order of the court. So that means that as it exists right now, there's no end date to when the stay of enforcement order is suspended. There's no end date right now. So I think it's important for us moving forward to recognize that and perhaps ask for immediate enforcement in all cases in light of this administrative order.
Yeah, although it's important to note that 2.614 already exempts from the 21-day automatic stay temporary orders, pre-judgment temporary orders in domestic relations cases. So we're really only looking at the issue of judgments and post-judgment orders that would be considered final orders, like a change of custody order. So, one of the things that judges and referees are going to have to deal with is, if they're entering orders for changes of custody, the party on the losing end of that might say, "That's fine. Try to enforce it." So it's that's where you're going to have to anticipate going in that we've got this extension or tolling of 2.614, and if you're a trial court counsel, ask, in your request for relief for immediate effect of any change of custody order.
Well, thank you, Scott and Trish, for joining us today, and for everybody else who attended. I wanted to let you know about next week's topic. It's kind of launching off of last week when we did evidentiary hearings via Zoom. Next week, we're going to be delving into privacy issues in the era of family law hearings via Zoom. So we look forward to seeing all of you again, and we're going to, there's been a lot of conversations among family law attorneys in the past couple of weeks about this issue. So look forward to seeing you next week. Again, thank you. I'm going to stop the recording. Have a good day.
Okay.